see, yeah, limited power of attorney was strictly to Mr. Baker, yes.
Good morning, everyone. Good morning, good morning, good morning, good morning. Good morning. How you doing this morning? All right.
Let's figure this out.
Good morning. I'm glad you came back. Good. So that means if you come back in 3 days, that means you can't ever leave. Yeah, we met Miss her. Yeah, she is our new this was Vivian. She's the assistant county administrator. She's our boss over several divisions, but our division.
Could he zoom in?
She's our environmental tech.
I think we could get him on
If
the
they
phone.
move, yes.
I'll check with the board.
Started
Okay.
yesterday.
Oh, wow.
Yeah, we can get on the phone. It was funny. I mean, he was like,
I think she
"You want me to go or do you want to go?" I said, "Look, I'll go. I need to go since I'm the owner." And it was funny. We just that was a breakdown in process.
What's your name?
Yes,
Scott
but
Delaney.
briefly, yes.
Yes, yes.
So, I think I've figured out what we can do here.
But it should be.
Let's do this. Let's do this.
I think on the organization it said Gary Baker Delaney.
I'll blame my engineers for this. And Gary.
The power of attorney is to Joseph Baker, who works for the company, but Gary's not here, the owner of the company is here. So we're trying to see if we can do this with them.
Can you just fill out a form?
Well, it's a power of attorney because PCC
Gotcha, gotcha.
doesn't own it.
I guess the intent of the power of attorney was for him to represent the company
Right.
and the thing, so I guess the.
Is that the one we have today?
Yes.
I said, we gotta make this, I mean, if we're it.
I know. Well, that's why we're trying to have a little more.
Trying to see if I can find power of attorney if it has the company name on it, then
That's what I'm looking
it's
for here.
specific to
We can
Gary.
fill out
It's
another one.
specific to the company.
If Chris so we can fill out another one? Another one? She has to set the bar for that.
It just says Garrett Baker. It does.
It's complicated because we've got multiple,
Right.
owners here.
Because you never know about how these things, someone may not like it, and then they start pulling public records.
Right,
And here
right.
we go. I know you, yeah. Yep,
That's why I'm.
absolutely, I agree with you, Drew.
So, do we have like a contract for sale or anything? Because our property appraiser's still showing everything under either Pensacola Christian College or Chris Tex Landholding.
Yeah, so we have a contract.
Okay. Could we get that?
Yeah, absolutely.
To us and download?
Yeah, I should have the latest amendment right here.
Is the contract to, TC and Pensacola Christian?
The contract is Delaney Property Group, which is my company.
Who was it with?
You're buying it from Chris Land
You're buying it from Chris Land,
and
correct?
PCC.
Correct.
Okay, yeah.
Are y'all Florida LLC or?
I'm Alabama LLC.
Alabama, okay, perfect.
So here is it's the second amendment. Sign that down. This is the.
Can you forward that to me?
Yeah, absolutely.
That'd be perfect.
What's your email?
A, D, is it Delta, H, L, M, E, R, at myscandia.com.
Especially since this is outdoor storage, and sometimes that can become very challenging with the neighborhood.
I can get the original as well. Original contract from here right now. Like the words are grabbed out of my computer if you want me to.
Oh, no, I was gonna say this would be enough to get us going.
On the first page of the application, his email says Garrett Baker Landholding LLC, also any kind of reference.
We can just drop by.
Sorry about that.
No worries.
Okay, Mississippi. Where's that one?
We almost got it worked out, y'all. Give us a couple more minutes. We almost got it worked out.
Already got that one on it. So now I'm looking for. Yeah, we're good, we're good.
Do you want me to send it in the mail, or just like, we have a couple things to screen for evidence where we can.
Yep.
We have.
Yeah, let's go.
Can I get y'all's blue pens?
Sure.
Alright, so,
Yeah.
You wanna have it pulled up and then have Kristen?
Let Kristen look at it, because it gotta be, yeah. And I agree with Mr. Godwin, we used to, yes, sir.
Before we go any further, if we don't really start discussing it, then we need to be on the record.
Yeah, yes, sir.
That's what I was gonna say.
Let Kristen
Yes, sir.
bring it up and let us
You
discuss
want
it.
to go ahead and go on the record now?
Yes, sir.
Yes, sir.
And she can chime in.
And I do have my mic on today, so.
Yes, sir.
First, I want to welcome everyone and wish on behalf of the board, everyone a Merry Christmas and a Happy Holidays as you would celebrate them. And so we're very fortunate to have a board and that has had some interesting cases this year, and we appreciate the help.
Get ready.
Yeah, and we appreciate the help of the staff and Mr. Jones and certainly Andrew. Okay, we're here this morning. The meeting of the Escambia County Board of Adjustment, December the 20th, 2023, is hereby called to order with 5 members present. We do have a quorum. Will the clerk please swear in members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of the staff's resumes have previously been provided and remain on file for reference. The board has previously recognized the staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for December the 20th, 2023, with the Development Services staff findings of fact, has previously been provided to board members. The chair will now entertain a motion to accept the meeting package in evidence. Do I have a motion?
Motion.
We have a motion by Willie. Do I have a second?
Second.
We have a second by Ross. All those in favor, please raise your right hand. The motion passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
Motion.
We have a motion by Willie. Do we have a second?
Second.
We have a second by Ross. All those in favor, please raise your right hand. The motion passes unanimously with all members in favor. Members of the board, have you reviewed the resume and transcript of the Board of Adjustment meeting held on November the 15th, 2023? Upon review of the resume and the transcript, are there any additions, deletions, or corrections? Seeing none, the chair will now entertain a motion regarding the hearing resume for the Board of Adjustment meeting held on November the 15th, 2023. Do I have a motion?
Motion.
A motion by Willie. Do I have a second?
Second.
We have a second by Marty. All those in favor, please raise your right hand. The motion passes with all 5 members in favor of the motion. Now, could we move to the purpose of the Board of Adjustment and the conduct of this meeting?
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the Board of Adjustment may be subject to cross-examination. All documents and exhibits of the Board of Adjustment considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the Board of Adjustment will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the Board of Adjustment relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the Board of Adjustment. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside. The development order or permit may be revoked, or development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the Board of Adjustment for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the Board of Adjustment decision. The date of the Board of Adjustment decision shall be the date the Board of Adjustment voted at the conclusion of the hearing. Whenever the Board of Adjustment denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the Board of Adjustment decision. Any person aggrieved by a decision of the Board of Adjustment relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the Circuit Court for review. Each individual who wishes to address the Board regarding a particular issue must complete a blue Request to Speak form and submit it to the Clerk of Board. These forms are located on the table at the back of the Commission chambers. You will not be allowed to speak until we receive one of these completed Request to Speak forms. We must have these completed forms for public record.
All written or oral communications outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed to be prejudicial under Florida law and must be disclosed as provided in Board of County Commissioners Commission Resolution 9613 before decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue, please identify themselves and describe the communication. This morning, the board will be considering case number CU 2023-16. The address is 104, 110, 112, 118, 122, 126 Airport Boulevard, and the 100 block Airport Boulevard. The request is to allow outdoor storage. This has been requested by Garrett Baker, agent for Chris Tex Land Holdings and Pensacola Christian College owners. And it's my understanding, Andrew, that the applicant is not present.
That is correct.
Well, if the applicant isn't present, then I believe that there is going to be a difficulty in hearing this case because the applicant is, by the very name, the applicant. And I'm uncomfortable hearing evidence that isn't presented by an applicant.
All right. That's obviously the board's prerogative to move in whatever direction you so choose. What I will tell you is I've done a quick search here and grabbed some documentation. Yes, per the property appraiser, the owner of those properties, so at this time, Pensacola Christian College Incorporated and a subsidiary of that, which is the Chris Tex Land Holdings LLC. We also have now a purchase agreement between Pensacola Christian College Incorporated, Chris Tex Land Holdings LLC, signed by Troy Shoemaker, their registered agent, to the Delaney Property Group LLC, which is an Alabama limited liability company. Their agent on here is Scott Delaney. Now that's on the purchase agreement. What I did was I went to the Florida LLC lookup for Chris Tex Land Holdings LLC, and showing that Troy Shoemaker is the current registered agent per the state. Also went to the Alabama Secretary of State's website there for business entity records, and I have there for the buyer listed in the purchase agreement of the Delaney Property Group LLC. Registered agent name is Mr. Delaney that's here with us. I just wanted to give you that information for the board to decide how you want to move.
Oh, and one thing before we go any further, have there been any ex parte communications with any board member concerning this application? Seeing none, for the record. Mr. Delaney, is he the applicant?
Mr. Delaney is a registered agent for the company that's buying the property, that has the purchase agreement, that appointed the agent.
Well, but he's not the applicant.
That is correct.
I'd like to hear from the board. What are your thoughts, gentlemen?
Mr. Chairman, I agree wholeheartedly with your synopsis of the applicant not being here. Then it's not something we can really analyze and approve or disapprove. I agree with you.
Willie?
Mr. Chairman, based on previous cases, there's one that I can think of right now where we didn't see the case because the applicant wasn't here. I think it's only fair for us to continue to give everybody the same treatment. And, you know,
And as I said, legally, I don't know how you hear an application from a person or from an applicant that is not present to present it, because there would be no competent and substantial evidence, in my humble opinion, that would be valid because it's not presented by the applicant.
All right, sir. If that's the direction the board wants to go, I believe we would need let's put it on the record that no facts of the case have been presented by anyone.
Yeah, that's correct.
That's why I'm saying I'm not sure how you would go about voting.
Drew,
well-
I did want to mention, while there would not be any competent substantial evidence that could be submitted by the applicant, staff has staff's findings that could be submitted, and that would serve as competent substantial evidence. I'm not suggesting that the board has any obligation to hear this case today. It's certainly within the board's discretion. If they would like for the applicant to be present and present that, but staff has their findings, and that is competent substantial evidence, and I believe staff has recommended approval. So I just wanted to note that.
And I would agree that staff's evidence would be competent and substantial, and we certainly appreciate our counsel's opinion. The problem I have is that the applicant isn't here to present evidence on its own behalf. And without that, I don't see how we can hear the case. It's kind of like unrelated parties all saying or presenting evidence in a matter in which they are not a party to. And that's kind of where we are, in my humble opinion.
And Mr. Garland, and we do understand that, because these, as Kristen always tell us, this board, the next step is basically there's an appeal, it go before the circuit court. And any procedure or issue has to tendency basically get thrown back to make these cases get overturned. And we do understand, we respect if that's the decision, we respect that. And it's best to be, sometimes it's best to be on the safe side, because you basically, it's the court process before it goes up. And these technicalities, I've seen it many times, they can cause things to get sort of awkward.
Marty, did you have something?
I agree. I agree with you. I think with the lack of being able to question the applicant, we're missing part of the information we need to make a wise decision. I do have one question though. Is there anyone in the audience that is here to promote or refuse or not accept this?
I think the engineers are present, and fact is, in fairness, while we're not going to receive, at least in my understanding, and I, of course, would bow to the board's collective decision, but I have no problem receiving comment from the audience, from the engineers, if they wish to speak. But I would not consider what they have to say as evidence in the matter before us, but simply commenting on whatever. I mean, so
Well,
that is available.
I would think if it's the board's decision to not hear the case that's scheduled, then the board would need to take a vote and perhaps decide to stay the proceeding and reschedule to a subsequent date.
I would ask for a continuance, not to drop it, because we don't want to have
Well,
to.
I was thinking along those lines.
Okay,
too.
thank you, sir.
Ross, did you have anything?
I was thinking more like what Willie was saying, if we've done it before this way, just to keep the fairness, we should continue.
I would ask our counsel, I think the engineer wants to say something. Would it be all right to hear not as evidence, but simply public comment? Would that?
Public comment would be acceptable. But if you're not conducting a hearing, then you certainly should not be receiving any evidence.
No, I would not
So
contemplate
we are
anything.
at a public meeting, and yes, you may receive public comment. Typically, though, public comment,
It comes after
yeah,
the votes.
it's a bit awkward procedurally, to be perfectly honest. And so if you're not gonna, it is within the board's discretion if you wish to receive public comment. However, I
All
don't know
right.
that there's any relevance to receive public comment if it's strictly pertaining to the facts of a case that you're not hearing.
Right. All right, gentlemen, I think the best way to handle this, do I hear a motion for the continuance of this case to be set by the staff at the next,
Available.
whenever, is convenient with the applicant and with the staff.
Motion.
Second.
We have a motion and a second before the board. Is there any further comment? Seeing none. All those in favor of the motion to continue this matter until a later time, please raise your right hand.
And Drew, does the board need to address who will bear the cost?
Thank you. I was just about to mention that. The cost associated with this will strictly be the advertisement and mailing cost because the county's board is the one requesting the continuance. The county will bear those costs. And no cost to the applicant.
Okay, the county is assumed cost.
Yes, sir.
All right, that's acceptable to the board, I'm sure. Okay, then we will address this at a time later, after the first of the year. So, are there, Andrew, are there any other items we need to?
Well, we do have some comments, I believe, from the public regarding that. I do want to let you know, we do have an issue before development review today that if the project is approved, I do anticipate a challenge to that. And we have another one out there hovering that might be challenged as well, in which case we would have to set up administrative appeal hearings. So just be aware for your schedule next month or so, we may have these issues out there.
Okay. And so you would think they would be scheduled in January? Is that your best guesstimate on the situation?
January to early February. The way the code is written, they have a timeline to appeal. Once we receive that appeal, we have 30 working days to schedule a meeting. So it would be somewhere late January, early February timeframe.
Okay.
And we want to, and we do want to thank the board because for all your hard work. I mean, working with these boards are not easy. It's sometimes the pay don't always match up. But we thank you for your volunteer, for your service. It's not easy, and we appreciate the county attorney office, especially Mr. Christian, who hanging there with us all the time. So it's been a blessed year, and we do have some things coming down the pipe. I want to thank Mr. Andrew Homer, who is the deputy director, and his consistency and knowing the board, knowing how to work these cases through the system. Ms. Rachel, want to thank her. She's our development service coordinator, and along with our Miss Debbie. She don't say much, but we're just glad to have her always present with us. And these type of procedures, because they are very, very technical, and it can get sort of awkward, and it goes to the court. So we thank you for the work that you do with this board.
Well, as I said, we certainly, I'm sure I'm speaking on behalf of the board, we appreciate the staff and Mr. Jones and Andrew, and we couldn't function without Rachel. She is the one that makes all the little wheels go round and round. So we appreciate her. Any words from our council?
No. Merry Christmas.
Okay.
Happy holidays.
Yeah. Oh, gentlemen, would you like to receive some public input? Not, we have disposed of the case, but this would be put in the realm of public comment. If you would like to hear it, now would be an available time to do it. Is that the consensus of the board?
Most definitely.
Okay.
Since
Sir?
they're here and would like to speak, it would be
All
the
right.
chair's discretion.
Sir, would they be sworn, or since this is public comment?
This is just public
Just a
comment.
public
This isn't-
forum.
You're not taking testimony.
All right. All right, sir.
My name's Patrick Hartman. I have a question for y'all. Do we not do video conferences in here that you could have someone who's not present in here be able to give testimony? I mean, the courts allow it, so why wouldn't the county commission?
We've not, I'm
hasn't-
trying to think.
I mean, y'all didn't do it during COVID?
it's-
That you would
it's-
allow Teams meetings for people to give evidence?
It's a technology issue with the system that we have.
So y'all are going against basically all the court systems by not allowing it? Just
So-
curious, just wanting this on the record.
No, we're not going to, no, we're not going against the court system. We have our county attorney's office. If we were, they will always advise us on what to do. So we are not going against the system. We are always listening to the advice of our council, and they are the ones to provide direction along with our board of county commissioners. So I don't think there's an ability.
No, I'm
to-
just curious for future reference on other projects.
Maybe we could do a FaceTime.
Sir, we need you, if,
I'm just curious for future cases that if someone is, say, from Washington State, they wouldn't have to fly down for a 30-minute meeting. Just curious. In the future.
apparently, as Mr. Jones has said,
Yeah.
our technology is not such that we are able to do that. There's no prejudice or
So
no reason other than that we just aren't technically able to do it.
Okay, I was just curious.
Okay, thank you, sir. Yes, sir.
What do I need to swear in or?
No, no. you're
Okay,
fine.
okay, good. Well, first of all, thank you, and I understand where y'all are coming from. The last thing we need is some sort of a technicality where y'all make a decision and it gets overturned and somebody argues. So I have no issues with that, understand that. There was a mix-up between Garrett Baker and myself. He thought since I'm more familiar with the company we're putting there and the owner of the company, he didn't understand the exact rules of this. So I apologize for, wasting everybody's time here this morning. And but I didn't know, I was just gonna ask real quick if we got him on a FaceTime call and put him up here, and he'd be able to speak into the microphone, would that be something we could do? I'm not trying to change the thing. We can obviously come back again, and like I said, it's really our fault because Garrett was the representative and we got mixed up on who was supposed to show up here. I'm the owner of the company, and he works for me as our senior project manager. So either way, I just didn't know if there was, I know y'all have closed it down and everything else, and I don't know all the rules of that, but just lobbing a Hail Mary there so we don't have to come back, but understand either way and appreciate your time.
Thank you, sir. Is there any other comment? Well, hearing that, I believe we've come to the time of adjournment if there are no other issues. And we will be here in the new year. And again, we appreciate everyone coming and thank you so very much for your attention. And with that, we adjourn.